welcome to this edition of John's Rants. I'm John Giardinelli, Association Counsel, and I'm going to do a little potpourri today. There's been a lot of topics that have been coming up lately, both at the association. We did some professional standards training, so I want to give you a little brief report on what the professional standards people have to say. These are the people that hear both your arbitrations and the grievances, hopefully, which will never be filed against you. So I want to talk about a couple of things, and then I want to tell you about a couple of programs that are coming up. So first of all, let me tell you about the programs. There's going to be two that I'm involved in, and then of course, almost every day, certainly several times a week, the association puts on programs for training. There's two that I'll be involved in March. One is on March 17th. I believe it's the Great Wolf Lodge. I think that's the name of the place. It's in Anaheim. And Barbara Betts, who's a phenomenal broker and past president of Pacific West and CAR director, a member of Region 23, which is Pacific West and Tri-County. And she's going to be with me. And we're going to do an all-day, very deep dive into the new RPA. We're going to talk about some of the forms. We're going to talk about the changes. We're going to talk about risk management relative to the form. And that is on March 17th. It is a live event. So hopefully you'll be able to join us. And then on a Zoom event on March 24th, we're going to do a legal panel. Again, Barbara Betts is going to moderate it. I'm going to be on the panel talking about realtor issues, code of ethics issues. But I've invited two of the finest lawyers that I know to be with me. Stephen Spile, who is a risk management attorney, has his own firm, and specializes in broker defense and broker insurance issues. And David Bright, who was one of the best broker defense trial lawyers that California has ever seen. He is now a retired mediator working for West Coast Resolution. So the four of us are going to put on a program. You are invited to send in questions you have about risk management issues. Send them to Lori S. at pwr.net, and she'll get them to us, and we'll be ready to go on March 24th. That is a Zoom event, and you'll be able to get a link through the typical means. So what's hot at professional standards? Well, the grievance professional standards hearing officers and the boards of directors met last week. Of course, I am recording this on February 24th. So when I say last week, the week prior to that. And a couple of things came out of that. Number one, of course, we have a very unusual market. 60% of transactions now are in some form or another non-contingent. And so what do you need to do to discharge your ethical responsibilities when you're making an offer or in a transaction that involves non-contingent offers, escalation clauses, deposit disputes, and dual agency? We talked about that. We put together some hypotheticals, and it became very clear to me that number one, we're going to talk about all those issues in depth at both the RPA class and at the risk management class we're going to have. Then the hearing officers came up with a 3-step process that they're going to look at to determine if you breached your ethical responsibilities. Number one is they're going to assume that you have the knowledge and the expertise necessary to discharge your responsibilities to your clients. Now, that doesn't mean you're going to have to be a law professor or someone who has way more experience than you do. You're going to be judged by a basic standard of care, but you have to have training. You need to understand the contracts you're asking these people to sign. You need to understand that what the forms are and what they say, what's available to you, and then you need to continue that education on a regular basis. They're going to be looking at that. And I'm going to talk about the broker's side of that in a second. Number two, they want you to properly advise your clients. As I discussed with them, right now realtors have sort of a very difficult situation. On the one hand, your clients really want these properties. They really want to get them sold. Multiple offers, very complex. A lot of people, particularly new home buyers, are dealing in a very complicated, complex situation. They need to make offers that are in competition and better than others. And lots of times that means waiving certain contingencies and so forth. On the other hand, you have ethical responsibilities. The DRE is going to be looking, and of course the courts themselves. So that's why they said, look, you just need to provide proper advice. What does it mean to waive a contingency? What should you do if there's a deposit dispute? How do you properly draft an escalation clause? So all of those things are going to be the topics of these upcoming seminars. Be happy to answer your questions, but you need to make sure that you understand how to give that advice. Go to CAR's website, look at some of the things they offer, and so forth. And then thirdly, you need to properly document what you and your clients talked about and send that to your clients so that you can establish, look, we discussed these issues. They made the decision. I gave them their options. So that was very, very interesting. It was a 2-day event, and I was very proud to be standing in front of such dedicated people, and they were very thoughtful. They're not vigilantes, and so they want to be fair, but they also want to make sure that all members are protected from unscrupulous behavior and that the public is also protected. So what about the broker? Well, there's Lori said that she's getting a lot of calls because there's this fiction that because real estate agents and broker associates are independent contractors, that brokers cannot require that they attend lunch and learn, certain programs offered by the board or by CAR, or programs offered by the brokerage themselves. That is absolutely false. So let me give you some very important guidelines on that. First of all, a couple of years ago, there was a new statute that was passed that had very negative effects on most independent contractors. It was called Assembly Bill, or AB 5. However, because of the quality of the legislative representatives up at Sacramento, the CAR people were actually able to carve out an improvement to the situation inside organized real estate. Number one, it was made very, very clear that real estate agents and brokers are independent contractors. Number two, that they laid out the framework that in order to remain an independent contractor, you need to have a license at all times, and the license needs to be appropriately with a brokerage. Number two, you need to have a signed contract with that brokerage. And number three, your primary income is based on what are called output contracts. Output contracts are essentially commission type agreements. So most of you meet that criteria. But then it raises the question, well, if you're an independent contractor, can the broker require you to do certain things? Because if he does or she does require you to do certain things, has that put you in the category of an employer, or excuse me, an employer-employee? And the answer is no under most circumstances. While it's true that a real estate broker cannot require you to do some of the things that are talked about in prior cases that dealt with independent contractor versus employee law, it is made crystal clear in AB 5 that if a broker is responsible to supervise in any particular area, that they can require you to take classes that go to those areas. So, for example, issues relating to your license, issues relating to material documents, issues related to fair housing. There are about 7 or 8 categories that a broker must supervise based on the Department of Real Estate regulations, specifically Regulation 2725. And if a broker fails to provide written policies and training and so forth, they can be held to be independently liable for actions that are taken by their agents. So it is absolutely untrue that a broker cannot require training on those issues. Additionally, the broker can require training on issues relating to the contracts and forms that that you commonly use. For example, if your broker required you to take classes or programs on the new RPA that came out in December, that is absolutely appropriate. The same with forms, etc. So obviously, it's something you should be doing on your own, but a broker can require that. And then lastly, a broker can require that you take training as required by the law. For example, there are requirements in California for sexual harassment training on a periodic basis. And of course, they can make you take those programs. The same is true with the multiple listing service. They can make you take programs and classes on the multiple listing service, because these are their listings that you brought in and are putting into the MLS pursuant to the MLS rules. And so you need to be able to understand the MLS rules. And in today's ever-changing market, the MLS has current rules that are very, very important. So with all of that, it is absolutely and abundantly clear that both the DRE and the board will expect a realtor to supervise. That includes the working with the agents in the office to make sure they have proper training. Another issue that Lori said is quite prevalent right now are the issues of signs. And so I want to kind of go over that with you real briefly, because failure to adhere to sign ordinances and the like could get everyone in trouble for actions you may take. So a couple of background pieces of information just to remind you that in order to put up a sign, you need the permission of the person upon whose property the sign is going. So for example, to put an open house or a coming soon or any other type of a for sale sign on a person's property, you need to have written permission or a listing agreement, which of course gives you that permission. You need to understand that if you're putting a sign in the right of way, then you need to make sure that the local jurisdiction, city, county, whatever it is okay with that. And then what are their rules and what are their criteria for putting those signs into the right of way. So again, if you're putting it in a right of way, you need to check local government ordinances. If you're putting it on private property, you need to have written permission or a written contract, and then you need to follow those rules and the instructions given to you. If it is in the public right of way, you need to understand whatever the local jurisdiction's rules are, and you need to follow those rules, as well as the Department of Real Estate's guidance for advertising and the association's rules for advertising under Article 12 and the MLS rules. All of that needs to be complied with. We have a booklet that is on the association's website on advertising guidelines. We provided it to the association so that they can give it to you at no charge. It is a very good book. I have to update a couple of things in it, but by and large, it has everything that you need. A couple of issues you should be aware of. Never block sidewalks. Most ordinances have safety and other provisions. Never ever block any type of handicap access. Be very careful about being unsightly. If you drive around communities on the weekends, many times there are dozens of signs in a particular area which create safety hazards, which create aesthetic hazards, and again, There may be a ordinance that limits the number of signs in any given area at any given time. And also, there are many ordinances that have provisions for rules regarding putting signs up and then taking them down. For example, many cities allow open houses now as the CDC rules are being pulled back. They allow the open house, but they require that you put the signs up no earlier than a particular time on a Thursday or Friday, and you take them down no later than Sunday or the Monday. So be very careful and aware of those, and also be careful that you don't run afoul of the local code enforcement, because they could be enforcing rules by taking your signs, and it's going to cost you a bloody fortune to get them back. So, and also remember that you have responsibility to your fellow realtors. If a few bad apples are going to spoil the pot, then and we've seen it. We've seen it before where cities have said, you know what, we've had enough of realtors not obeying our rules. We're going to change the ordinance. And as they can do, it is perfectly legal. They can ban signs for everyone in the right of way. And if they do that, or they limit them extremely, then everyone suffers because of the actions of a few bad apples. So be aware of that. Also, a couple of things, and then I'm gonna talk about the next rant, because we're gonna talk about a couple of other issues that are gonna take me some time. But the board has one of the most innovative programs that have ever been seen. Both CAR and NAR have approached the association about sharing the program, but unfortunately, because of some past history, they're not going to do that, and these are unique to the association. It's called the RED program. Phenomenal program, unique to most associations. Basically, what happens is, if you're not happy with the conduct of another realtor, you can contact the association. If you're getting close to filing an ethics complaint because of time or because of some other issues, you can go ahead and file the complaint, but then you can ask that the association staff, who have been incredibly well trained, intervene on your behalf. They will call the broker for the party who is alleged to be doing wrong. And in over 90% of the cases, they're able to resolve these issues before it ends up blowing someone's deal, or before it ends up going into a full-blown arbitration or full-blown mediation. So that is a tool that you have available. I also want to let you know about something that is also was unique to the association, and that is the way the association deals with CRMLS fines when they're appealed. You have the ability to ask for a paper review of whatever CRMLS has cited you for. It's going to cost you some money, so don't do it frivolously. It's not cheap, it's $100, but you can't be fined any more than what CRMLS has indicated is going to be your fine. So your worst case scenario is you will pay the $100, and then you will pay whatever the fine that CRMLS has imposed on you, in the event that you believe it's incorrect. You're also entitled to a full-blown hearing. But remember, if you ask for a full-blown hearing, before it goes to hearing, it's going to go to the grievance committee. And if you are a habitual violator, say, for example, you're constantly violating the coming soon signs, you may end up with an ethics complaint also filed against you, in addition to the MLS complaint. Be very careful, by the way. We've noticed some real problems lately with people using other people's photos. If you've hired a photographer, you've signed an agreement with them as to who owns the photography rights. If you've hired a member of the list that CRMLS has who's a photographer, then they've already agreed to abide by all the MLS rules. But one thing is clear, the photographers did not give other people the right to use those photographs other than in accordance with the MLS rules. For example, brochures to sell other people's property or things like that. But if the listing has expired with the broker that hired the photographer, you cannot use those photographs. That is a copyright infringement. All right, so we're going to do another rant in a couple of weeks, and I want to tell you what we're going to talk about. Unless something very, very special comes up, which it could. There are currently 3,000 bills before the California legislature. But I'm going to talk about issues relating to both presenting offers and issues relating to protecting your commissions. Lori tells me that those are some pretty serious charges, and so we're going to cover those issues in depth. We're going to talk about understanding the procuring cost guidelines, using buyer broker representation forms, and all of that. We're also going to talk about presenting offers in light of the code of ethics and your obligations to not only your clients, but to other realtors as well. So for now, this is John Giardinelli signing off. Thank you for attending, and we look forward to seeing you hopefully on either March 17th at the live RPA class or on Zoom on March 24th for the legal panel dealing with liability trends in organized real estate. So until then, thank you very much. Be safe, and we'll see you soon.